Hi, welcome back to La Belle Vie and our weekly law update. So I've got a couple of updates this week. First, with respect to Murdaugh, as everyone probably is aware now, the jury did come back with a finding of guilty on all of the counts. So that happened late last week. My first takeaway was I was kind of shocked at how it all just came together. I mean, it's always possible that a jury's not going to deliberate for very long, but I think because the trial had gone on for 6 weeks, and because it was a murder case, I think a lot of us commentators thought that the jury would be there longer deliberating than a few hours, but they didn't. And what that tells me that, and I think what we've already heard from a couple of the jurors that have come out and spoken, is that I think what's probably clear is that probably a lot of these jurors had their minds made up, and that's fine. And I also think that this relates into my second takeaway of the case, is that, in my opinion, the prosecution, the strongest piece of evidence that the prosecution had, and ultimately I think was the kicker, was the dog kennel video with Maggie and Alex's voices. I think when that got into evidence, I think that's the reason why Alec Murdaugh decided to testify. And I think that, coupled with the liar, 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 I think that was so compelling. And I think that the prosecution's closing arguments, and I didn't really get to talk about it because everything happened so quick, but I thought that they started slow, but I thought that they ended really strong on that point, the liar, liar, liar. And again, from the little bit that we've heard from the jurors so far, that seemed to really resonate. And I think that's what we all were kind of wanting the prosecution to do throughout the case, was focus on, things that were around the time of the murder and, not so much of the financials. But in any event, the state had explained that the financials were important. And I don't know that it necessarily isn't, but that leads to my third takeaway, which is not going to be surprising. This will be appealed. The defense attorneys made that very clear at their follow-up conference after the sentencing. They are, going to appeal on state grounds on the character evidence, which is, I did a whole video of it. Actually, if I remember, I'll link it up here. But basically, the argument that they've been making is that this was all it's inappropriate character evidence. It shows propensity, and we don't convict people based on propensities. As you may recall, the court disagreed with that and found that it went to motive evidence, which would be appropriate. So that will be appealed. I'm not surprised. We'll have to see. Appeals are hard. I mean, I think that there's some really good, strong arguments for the defense, but it's always an uphill battle to appeal. So we'll have to see, but they're definitely going to appeal. But I thought what was more interesting was that the defense made very clear that the other reason for their appeal is going to be based on federal constitutional law. And so right here, I'm going to insert the objection that the defense made at the time, and you'll hear the objection, and then I'm going to insert the court's specific ruling on that objection and let you know my thoughts. But basically what this addresses is a Supreme Court case called Ohio v. Doyle. And basically it addresses what happens when a defendant decides to take the stand, tells something that wasn't said before, and the prosecutor questions the defendant on that silence. Why didn't you tell us before? And what the Supreme Court has said is that's a violation of your the 14th Amendment and your right to due process. So here's the testimony and the judge's ruling, and let me know what you think. And I'll give some final thoughts on Murdaugh, and then we'll go to our next updates. So here we go.
That you ever before yesterday reached out to anyone through yourself or through your attorneys and reached out to anyone in law enforcement or the prosecution and told them the story about the kennels? Are you telling me that?
What I'm telling you,
answer my
Mr.
question
Waters,
first, please, sir. Answer my question first. Did you ever reach out to anyone in law enforcement or the prosecution and tell that story that you told this jury yesterday about the kennels before yesterday?
did I ever reach out to law enforcement to say, I want to tell you about the kennels? No, sir, I did not.
This is the Fifth Amendment line.
Pardon?
This questioning about him volunteering information on these charges violates his Fifth Amendment rights, and we strongly object. Any more, we have to make a motion.
The objection's overruled.
What I did was,
Answer my question first, sir.
Your Honor, for the record, he did not bring it. He was talking about financial
Sit
stuff.
down, Mr. Griffin. Mr. Griffin, you wanted to put something on the record?
Yes, Your Honor, thank you. During cross-examination of Mr. Murdaugh, he had testified that in relation to the financial crimes, that he had tried to meet with the Attorney General's office and that on multiple occasions, and that he had, from the get-go, had always been willing to sit down with them. He was specifically talking about the financial investigation and the charges which he received as a result of those investigations. Following up to that questioning, that answer, Mr. Waters then went to Mr. Murdaugh's testimony and the information he provided about being down at the kennel, and he said you had never provided that information to law enforcement and other people until today or yesterday. And Your Honor, that is a direct violation of Doyle v. Ohio, where the Supreme Court said that cross-examining the defendant about his failure to have told an exculpatory story after receiving Miranda warnings at the time of his arrest is a due process violation. The court goes on to say the defendant's post-arrest silence cannot be used against him, violates due process. And that's exactly what happened on cross-examination. So I want to make clear the grounds for our objection. Also would like to move to strike the question, strike the answer, and get a curative jury instruction that they are not to consider any failure of the defendant to come forward with exculpatory information after his arrest relating to the murder charges. Thank you.
Mr. Waters.
Yes, sir, Your Honor. Clearly, this defendant has given statements on multiple occasions, and that operates as a waiver under Doyle. Additionally, my question was not so limited as Mr. Griffin says, and it was in fact the defendant who made a point of saying that he had repeatedly tried to talk and put that in issue, at which point this was directly responsive to what he brought up. Additionally, this was also, all that was discussed were public statements of his counsel, who was an agent on his behalf and attributable to him. So there's no Doyle violation here. If Mr. Murdaugh had claimed his right to silence from the beginning and had kept that throughout, then the state would be precluded from commenting on the exercise of his right to remain silent. But one thing we know about Mr. Murdaugh is he has not remained silent at any point during this process, and he's the one that brought up this false claim that he had been begging to tell the kennel story, when in fact he did not do so till yesterday.
Doyle primarily addresses the issue of post-arrest silence. If an accused is silent following an arrest, then it's improper to comment on a post-arrest silence. It does not allow an accused or a person who's suspected to give contradictory information or to voluntarily give a statement or to voluntarily give a misstatement, as has been acknowledged here. I do not find any Doyle violation, and the record is protected. I certainly understand the defense raising any and all possible issues, and they can be raised, and you've done it here. the record is protected, but all motions are denied. Let's bring the jury.
So what's going to be really interesting is the defense arguments on the Doyle case. So what the Doyle case squarely holds is that they granted cert in that case to decide whether impeachment use, so just impeaching, calling someone a liar, use of a defendant's post-arrest silence violates any provision of the Constitution. And what the court held was that very clearly the use for impeachment purposes of the petitioner's silence or the defendant's silence at the time of the arrest and after they received Miranda violated the due process clause of the 14th Amendment. Post-arrest silence following such warnings is insolubly ambiguous. Moreover, it would be fundamentally unfair to allow an arrestee's silence to be used to impeach an explanation subsequently given at trial after he had been impliedly assured by Miranda warnings that silence would carry no penalty. I don't know. I need to look further into it because obviously I'm just reading the case. I mean, the case facts, I mean, they're very different. It's about a drug deal, obviously, but it just, I don't know. It's going to be really interesting to see what the defense has for that appeal and what they say. So I'll be looking forward to that. And hopefully we'll get to see that appeal. It's going to probably take a while because, as they mentioned, it takes a while to get the official record with the court reporter and all the transcripts. So, I mean, they have to file a notice of appeal within a certain period of time. I believe 10 days is the rule in South Carolina. But once that, it'll probably be months before we see the appellate briefs. So we'll wait to see that. But that's all we have for Murdaugh. But let me know what you thought. Were you surprised that the jury came back so quickly? Or did you think, once that video kennel, the kennel video came in, is that what decided it for you? Or was it the fact that, did you think he wasn't very credible on the stand? I'm just super curious. So let me know your thoughts. But anyway, I'm actually glad this one's over. That was a long case, and I'm really excited about my next one, which is going to be Sarah Boone. But in the meantime, I've got an update for Rust. Okay, so in Rust, the only update we have is that we have another civil lawsuit that's been filed. This time it was filed by 3 crew members, but it was filed in state court in New Mexico. So we'll have to see how that one goes. It's 1, 2, 3, 4. I count 5, not counting the one that they settled against, that Alec Baldwin and Russ settled against with the Helena's husband. But that's how many other lawsuits are going on. I'm not surprised when you've got such a kind of shocking, horrific accident that happened, and you've got, a state OSHA agency finding first willful serious violations that was negotiated down to serious. But in any event, when you've got something like that happens, this is absolutely expected that, anyone that was involved in it is going to bring a claim. So those claims are for blast injuries and anxiety and PTSD. So I'll keep you updated on those. The other thing just to remember as far as timing goes is since Alec filed his not guilty plea on the 23rd and Hannah filed hers on the 24th, 60 days from those 2 dates, the state has to bring their pretrial hearing. And we still have open Alec Baldwin's motion to remove the special prosecutor. That we don't have a decision on yet. So stay tuned for updates on those. Okay, now I've got to finalize everything out. I've got a quick update for Sarah Boone. Okay, just two real quick updates for Sarah Boone. First of all, I still haven't, the court still hasn't ruled on the defendant's motion for costs for a mitigation expert. I don't see that being an issue. I think it's just, they haven't ruled on it yet. And I think the docket system for a lot of these state courts, it's not like Pacer Federal, the federal online database where you can get all the information on federal cases. States, it's all over the place, each state. And Orange County is good, but it's not, they're not always uploaded immediately. So the court could have ruled on this mitigation expert, and it's just not showing up on the docket yet. But in any event, I don't foresee them. I don't see any issues with the court granting that motion. But more importantly, maybe, we know that there's some indication that her defense might be bringing the battered spouse defense. And as I mentioned in one of my first videos on the Sarah Boone case, in order to bring a battered spouse defense, or also now called intimate partner violence, that's more the modern term. But in any event, to bring that in Florida, you have to file a specific notice no later than 30 days prior to trial. And the notice has to basically set forth the particulars of your theory of the defense and the names and addresses of any names of witnesses. I don't think you have to give the addresses, but names of witnesses that you're going to bring to support that defense. So that's got to be brought no later than 30 days. Assuming we still have an April 10 trial date, that means time's ticking. So I will be looking for that this week too. I would assume that we would be seeing something pretty quick on that. But other than that, I think I mentioned before, I'm going to be doing some fun content on Sarah Boone case in anticipation of the trial hopefully going in April. So look for that next month, or this month actually. It's March, crazy. But anyway, thank you so much for joining and for subscribing. I know I've got a lot of new subscribers and I really appreciate it. I know everyone's busy and there's so much great content out there. I really appreciate you coming back and joining and having a little fun with Law and Crime. Thank you so much and have a wonderful day. And I hope to see you in my next one. Bye.